When is a retained attorney subject to removal for not being freely and independently chosen by an Article 17A ward? To find out, you have to read Matter of Jessica L.M, but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I normally cover New York Court of Appeals cases and I try to do it in 5 minutes or less. But this is a limited series I'm doing on cases related to elder law and estate planning. And this is tangentially related to that. This is a case of Matter of Jessica L.M. out of the Surrogate's Court of Suffolk County, Justice Messina. And the case citation here is 2023, New York Slip Opinion 02364, published by the Surrogate's Court on August 4th of 2023. The issue in this case is about the right of an Article 17A subject, a person who is developmentally disabled, to choose their own counsel with respect to a motion to terminate their guardianship under 17A of the Surrogate's Court Procedure Act. What you have to understand to appreciate how this case works and where it fits in is that every person has the right to choose and select their own counsel with respect to legal proceedings. And that's one of those guarantees that we have in the Constitution, under the Sixth Amendment and under the First Amendment. But the cases have held that it's not an absolute right. You have an absolute right to have a lawyer, but you don't have an absolute right to have a lawyer of your choice. And one thing you have to understand about Surrogate's Court Procedure Act 17A is that is a section of law where a person is determined to need a guardian based upon either intellectual disability or developmental disability. And it's a statute that determines the person is either intellectually disabled or developmentally disabled based upon diagnoses and specific instances in their life that determine that they have these intellectual or physical or developmental disabilities. So the other thing you have to know is that under the Surrogate's Court Procedure Act, in the 17A context, a person who has a guardian under 17A can move to terminate that guardianship, to vacate and dismiss the guardianship under SCPA, SCAPA, Surrogate's Court Procedure Act 1755. A person can petition to modify or even terminate their guardianship. So what are the facts in this case? The facts are that the subject of this case is Jessica. Jessica has been previously determined to be developmentally disabled and has a guardian pursuant to a previous Article 17A application. And her diagnoses were Asperger's syndrome, ADHD, bipolar disorder, learning disabilities, anxiety disorder, and mild cerebral palsy. She's actually got quite a high IQ of 133 on one test and 106 on another test. But the court appointed as her guardians her 2 parents, one of whom subsequently died, leaving her mom as the guardian, the sole guardian. And Jessica has a bunch of caretakers who make their money by taking care of Jessica. And the guardian doesn't like some or all of them. And so Jessica has this dispute with her mother, the guardian, about whether to terminate, whether to get rid of these caretakers. And so the caretakers start whispering in Jessica's ear, saying, you can move to terminate the guardianship so you can get rid of your mom. And they then tell Jessica she can move to terminate the guardianship. They find the lawyer that they then have Jessica retain, who's from Rochester, not Suffolk County. And that lawyer then makes a motion to terminate the guardianship under SCAPA 1755. It goes to Judge Messina, and he brings in MHL Article 8110, which says that a person is allowed to have a counsel of their choice, but that counsel must be freely and independently chosen. And so under MHL 8110, you're allowed to have a narrow inquiry, a hearing about whether or not, before I get to the merits of the application, let's have a hearing as to whether this lawyer is actually freely and independently chosen, or if he's the product of some kind of undue influence, or maybe he's just been chosen by an interested party. So Judge Messina conducts this hearing and determines his holding here is that although the right to counsel is absolute, the right to counsel of your choice is not absolute. And he says here, in this particular circumstance, because a financially dependent party, a financially interested party, who's interested in the litigation, caused the litigation, brought the attorney in, and because Jessica didn't get involved at all in the selection of the attorney and never even considered any other attorney, under these circumstances, the attorney was not freely and independently chosen and is removed. Judge Messina The consequence is Judge Messina removes that attorney as the lawyer for the AIP, for the developmentally disabled person, and then appoints an 18B counsel to represent Jessica for this particular matter. Doesn't dismiss the proceeding, but says, and takes no criticism as the attorney, but just says, this attorney was not freely and independently chosen. I'm going to appoint an independent counsel under 18B, and that person will carry forward this application. And that's the case of Matter of Jessica L.M. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.